Good morning, good afternoon, and good evening, depending on the time zone in which you're watching us. Welcome to this event, which is jointly organized by Bennani Associés and Delos Dispute Resolution in the context of the Delos Guide to Arbitration Places. This webinar will be posted later on the Delos website. Now, as many of you know, Delos dispute resolution is a very dynamic arbitral institution, which is chaired by my colleague and friend Hafez Virji. And it's not only an arbitral institution, but it's also a knowledge sharing platform. In addition to the numerous webinars that it hosts, you will find on its website the Delos Guide to Arbitration Places, which provides online practical overviews of arbitration laws in 60 jurisdictions and in a very practical and user-friendly format. You won't find a lot of doctrine, but practical answers to practical questions which corporate counsel and arbitration practitioners ask themselves on a regular basis. And this project is chaired by Professor Maxi Scherer and Professor Jungi Kim, and is edited jointly by Hafez Virji and myself, Thomas Granier. So a note for this year, we're currently preparing the second edition, which will be published in the first half of this year, with an increased number of chapters and new jurisdictions. All of these webinars panelists are members of the Delos GAP initiative, and we're very happy to do that together. And before introducing them, a few words about today's discussion. It will focus on enforcement of commercial awards in Algeria, England, and France. And the reason for this choice is that, of course, we know that one of the distinctive advantages of arbitration is that it's in principle a one-stop shop. In principle, there is no appeal, but we also know that a final award in a given dispute is not always the end of the journey. And when you have an award ordering the other party to pay a figure with a lot of zeros, and the other party refuses to comply with the award, well, the actual value of this award is really a function of your ability to enforce it. And this is why we're here today. Enforcement, we know, is a process. You have to go through a number of motions, and sometimes it's just a matter of getting a stamp on your award, but sometimes it's a more tedious process, and that this process sometimes requires a specific expertise to navigate through it. And today we have very experienced navigators who know the ins and outs of enforcement of awards. We have first Marie Danis, who is a partner at Auguste and Debouzy in Paris. She's admitted to the Paris bar, and her practice is dedicated to international arbitration and arbitration-related litigation, which includes enforcement of arbitral awards. We have Mourad Seghir, who is a partner at Bennani Associés, where he heads the Alger office. And he too focuses on international arbitration in various areas, and of course, including enforcement of arbitral awards. And last but not least, we have Opeyemi Longe, who is a lawyer practicing international arbitration at White & Case in London. Opey is admitted to the Nigerian bar and also focuses on international arbitration. Now, I'm going to leave the floor to our panelists, and we're going to move on to our first topic. A recommendation that we often make to our clients when embarking in an arbitration is to foresee enforcement ahead of the rendering of the award when there is a risk of dissipation of assets, for instance, and when this is possible. And that's the first topic that we're going to explore. Mourad, I'm looking at you. How is it possible, and how do I get, for instance, a provisional measure in an arbitration to secure my future awards under Algerian law?
Thank you, Thomas. I will say that in Algeria you have three types of provisional measures. The first one is a provisional seizure, which is governed by Article 646 of the Algerian Civil and Administrative Procedures Code. It is granted by the president of the tribunal before local court when two conditions are met. The first condition is you need to prove that the debt is certain and due, meaning that the debt must be duly established and that payment term has been expired. And second, you need also to prove that there is a fear of losing the right to collect the amount due once a judgment on the merit is rendered or an arbitral award will be rendered. Such as, for example, a fear of bankruptcy, a fear of losing a particular asset, or for another example, several creditors are claiming payment. So once you have obtained the seizure order, then it is notified to the bank or the person in charge or in possession of the movable or immovable assets within eight days to proceed with the provisional seizure. So this is the first category of provisional measure. The second category is a summary judgment procedure, which is governed by Article 299 and follows of the Algerian Civil and Administrative Procedures Code. Three conditions must be proven for the second temporary measure. The first one, you need to prove that it's the temporary nature of the proceeding that you are looking for. Second, you need to prove that it is not related to the merit of the case. And third, you also need to prove that there is a fear of losing a particular right, as I just described for the first scenario. Third measure is requesting an investigation. So before any trial on the merit or before any arbitration proceeding, under the Algerian Civil and Administrative Procedures Code, you can also request from the judge to order an investigation in order to either establish or notice a particular fact needed for the future claim on the merit. For example, you can request from the judge to order noticing that a plant is operational, not operational, noticing an abandonment of a work site, etc. So this is the three provisional measures that are provided under Algerian Civil and Administrative Procedures Code. Once you have obtained the provisional order, you have to notify it to the other party, and the other party will have 30 days to introduce a conciliation proceeding. Second point I wanted to discuss in relation to this topic is the difficulties we have seen in practice in relation to the provisional measures obtained in presence of an arbitration proceeding. Because under the Algerian Civil and Administrative Procedures Code, once the order is granted, you need to introduce a validation procedure before the Algerian court within 15 days from the issuance of the order. Otherwise, you will lose the provisional measure that has been granted. So the validation procedure is a procedure which is introduced in the same time as a claim on the merit before Algerian courts. Unfortunately, in presence of the arbitration clause, the Algerian judge has a very restrictive reading of this validation requirement, because as per the Algerian judge, within 15 days, a claim on the merit must be introduced exclusively before Algerian courts, and therefore they will reject the validation procedure which is introduced before without any claim on the merit pending before local courts. Finally, we say that it is still possible to introduce a validation proceeding by requesting exclusively the validation without going on the merit of the case. But unfortunately, we have seen in a very rare cases that the judge has approved the validation while an arbitration proceeding is ongoing or will be started thereafter. Thank you.
Thank you very much, Mourad. I forgot to mention something to our audience. Obviously, we have spared time for questions, which we will take after the, which we will address after the various topics that we will address. But feel free to send them in the chat, in the Q&A section, and we will seek to address them at the end. And Opey, I'm looking at you now after Mourad's very interesting explanation, and English courts are quite famous for their very efficient freezing orders. How do I get one?
Right. Thank you, Thomas. I mean, of course, like you mentioned, there's always that talk about the freezing injunctions in England. But then, of course, there's always some bits of technicalities in terms of how do you even get this. Also, there's the question of what is the basis, of the court's powers to grant these freezing injunctions. So generally, there are two possible statutory provisions that guide this process, and one of them is under Section 44 of the English Arbitration Act 1996. In particular, this section talks about the power of the courts to be exercised in support of arbitral proceedings. And then you have the second possible legal framework, which is the Senior Courts Act of 1981, which guides courts generally in terms of when they decide to grant injunctions. And having said there are two possible approaches, I just want to go into a bit more details in terms of these specific provisions. Section 44 of the Act says that courts can grant injunction for the purpose of and in relation to arbitral proceedings. So it's usually the case, especially where you envisage that an award, or you're going into a proceedings, or possibly you get an award that you then want to secure whatever outcome you might get from the proceeding. So in that way, you then apply to courts, which is why you have that provision of Section 44. And in particular, there's a requirement of urgency, so that for you to apply, for example, under Section 44 sub 3, there must be a requirement of urgency. That's when you can directly apply to the court. Otherwise, you then have to seek permission of the other party or of the tribunal. But of course, usually parties do resort to this provision when tribunal hasn't been set up, in which case you want a quick remedy, especially where there's a risk that asset might be dissipated. And the second point, which I mentioned, is Section 37, as to the general powers of the court, of course, which is not limited to arbitration and covers situations where you get a court judgment. So there's been a lot of quite a few debates as to what is the basis for applying for this injunction. So sometimes there's been argument as to whether you need to apply under Section 44 of the Arbitration Act, or you need to go via Section 37 of the Senior Courts Act. However, in recent times, I think there's a recent decision of the English court in 2014 that talks about the fact that there's been this argument about whether you do under both provisions, but then because parties did accept that the court can grant the order under Section 37 of the Senior Courts Act. So the court did not particularly make a final pronouncement as to whether you need to go via Section 44 of the Arbitration Act or Section 37 of the Senior Courts Act. But of course, in terms of the practical approach, it's always better to apply under both sections so that you are safe to be sure that yes, you are covered under both provisions. And of course, in terms of the conditions, being an equitable relief, all of those conditions for injunctions would apply in terms of, like Mourad has mentioned, in Algeria, you talk about you must have a good case, in a good course of action. And then, more importantly, there must be that real risk of asset dissipation. And that's where the practical issues about conducting your investigation to be sure that, for example, maybe there's been an attempt to restructure or to incorporate in offshore jurisdictions to cover assets. And of course, there are also some other standard injunction conditions, for example, whether it is fair to grant it and all other similar issues. And I think I should also mention, because like you mentioned, English court is famous for freezing injunction, especially when you talk about worldwide freezing orders. But then there's also that point that the court is almost always going to require you to make a cross undertaking. And by cross undertaking, I mean undertaking as to damages. So that if the court finds that it ought not to have granted this order, then you are potentially exposed to compensate the respondent. And that's really where it gets tricky, or where the claimant is exposed to potential risk. Because if it turns out that this order ought not to have been granted, you clearly get exposed to that risk. And so that's why it's always advisable for a claimant to consider whether this is the right course of action to take, or consider all of the other options. And that is why it's really very key to be cautious in taking this approach. So that's some of the points I wanted to cover. And in terms of also, I think I should mention, in terms of getting the worldwide freezing orders, there's also always a question about, because like I mentioned, it's not always the case that the asset must be within England. So the court can actually always grant on an order that covers the entire globe. But of course, yes, that point that you must, of course, evidence some element of link to England. So that's my comment on what we have in England and Wales.
Thank you, Opey. You uttered the word investigation at some point in order to indeed identify the assets of the other side, and these documents that you get via investigation can obviously serve on the merits of the arbitration. Marie, we have in France a very efficient tool for that, don't we?
Sure, thank you, Thomas. Yes, indeed, we've got a kind of mini discovery in France. It's Article 145 of our French Civil Procedural Code. It's worth mentioning it. It's not so usually used in order to gather information then to be able to get conservatory measures. However, it's a very efficient tool because the request is ex parte, so you can go before the judge without informing the other party, and then a bailiff is appointed in order to gather information at the premises of your opponent. It is worth mentioning that you need to think about this tool before starting the arbitration process. The main reason being that this tool will not be anymore available when the arbitral tribunal is set. So it's really thinking about that at the very beginning. I would like also to mention that conservatory attachments are available under French law, and that you have to check that there is no waiver of such possibility to go before domestic court in your arbitration agreement, would it be explicit or by reference to arbitration rules. And the test is rather stringent, but the same that Opeyemi and Mourad mentioned. You need to establish circumstances strengthening the recovery of your debt. So that's a quite harsh test to meet. And also, of course, you need to establish that you have a debt that is in principle grounded. It's also available ex parte, and then you've got a challenge process, and you need to be ready to start your arbitration proceeding within 30 days of the implementation of the conservatory measure. So you need to be ready, and it's really about setting the time and be able to file your request for arbitration.
Thank you very much. No doubt, and we already have questions in the chat for after our discussion on this first topic. Now, Marie, let's in respect of the enforcement process itself. Let's say I'm a client. I just got an award. It's fantastic. It's all in my favor. But there is a slight issue. The other side doesn't want to pay. Is it complicated? And this party actually has a bank account in France, or asset in France, that I know. So I have my award. I'm coming to you. Is it complicated for me to enforce in France?
No, it's a rather simple process in France. Mentioning that you are targeting, bank accounts located in France, I would advise you at the same time during your exequatur process to request a provisional enforcement in order to secure the recovery of your assets. And it's even easier with an award. Also, the award did not receive yet the exequatur. But to come back to the exequatur process, it's easy because it's an ex parte process. And you need to establish on the face of it, and it's a prima facie review by the French judge, that you've got an award, that within the contract there is an arbitration provision. So you need to have a translation of this award and also a translation of your arbitration provision. And you go before the judge, and it's very quick. The most work is getting the file ready and getting translation of all the paperwork. And the only prima facie review that the judge is going to conduct is to check that the award is not manifestly contrary to the French definition of international public policy. So I would say that the process is pretty quick and pretty easy, and in most cases the real debates are going to happen before the Court of Appeal in case the exequatur is challenged.
Well, that seems to be a fairly easy way to obtain the precious stamp on your award that allows you to enforce it. How is it? Is it so easy, Mourad, in Algeria before the Algerian judge? I think you're on mute.
Yeah, so, sorry. I will say that the process is quite similar to what Mary just described for Algeria, because you need also to provide for the exequatur an original copy of the awards. Original means with a signed copy. And that original copy must be translated to Arabic by a certified translator in Algeria. And it's also a gathering of a file related to the different parties. For example, if it's an Algerian company, then you need to provide a copy of the trade license of the company in order to prove later on its notification. And during the exequatur proceeding, the judge, similarly to what Mary described, will only review whether the award contradicts any international public order. And when we're doing this review, in reality, the Algerian judge will only focus in practice on the Algerian public order, meaning the reviewing whether the award contradicts any mandatory provision of Algerian law, such as, for example, any mandatory rule related to exchange control regulation, any mandatory rule provided related to indemnification principles and rules, etc. And once the judge, the president of the tribunal, of the seat of the arbitral proceeding, or if the seat is outside of Algeria, the tribunal where the enforcement procedure is introduced, then the party has 30 days to introduce an appeal in order to this time debate the content of the decision and try to cancel the exequatur. And before the appellate court, there is six grounds that can be reviewed by the judge. First, the first ground is whether the arbitral tribunal issued an award without an arbitration agreement or based on a void or expired arbitration agreement. Second, if the appointment of the arbitral tribunal or the appointment of the sole arbitrator is in violation of the law. Third, if the arbitral tribunal settled the dispute outside its assigned duties. Fourth, if the principle of due process was followed. Fifth, if the arbitration court did not justify its award, or in case of contradiction in the retained grounds. And six, if the arbitration award is in violation of international public order. And again here, the debate, it's a second chance given to the defendant to prove that indeed the award is in contradiction of international public order, which indeed is underlying any contradiction with any mandatory public order provision under Algerian law. And then in terms of enforcement, so once you obtain the exequatur and let's say the appeal was not granted, then you will seek the enforcement against the other party. In this case, the enforcement is organized in three main steps. The first step is to notify the final decision to the other party, which will have 15 days to proceed with the payment, with the execution, and failure of which, then the second step is to introduce a request of a final seizure order of either a bank account, if you already know the bank details of the other party, or movable assets or immovable assets. Once the judge grants the order is again notified to the bank or the concerned person, and a bailiff will request, once the assets are identified and the bank account has some money credited, the bailiff will request from the judge to obtain a reservation and transfer order of the identified assets. So the difficulty in Algeria when you have a foreign party is most of the time the accounts that you will size is the dinar account, the Algerian dinar account, which is, as per exchange control regulation, a non-convertible currency. Therefore, the money will be left within the bailiff's account, and you will have to introduce an authorization, a special authorization from the central bank, Bank of Algeria, to authorize the bailiff to transfer the money out, to first convert the money and transfer the money outside Algeria. I will say that it's very difficult to obtain this particular authorization. And therefore, most of the time, when you are dealing with privately owned companies, it's almost impossible to obtain the transfer. While when you are dealing with state-owned companies, such as, for example, Sonatrach, it is possible to enforce it in Algeria, because most of the time the central bank will grant such authorization. And also, Sonatrach has assets outside Algeria, and therefore you can seek also enforcement outside Algeria.
Thank you very much, Mourad. That was for this very detailed explanation. Opey, I think you wanted to say a quick word about this as well.
Yeah, I mean, I think that Mari and Mourad has, said extensively what we have in England, because in a way, the enforcement procedure is pretty straightforward, and that's why we call it a summary procedure, if all things go as they should. But of course, I think I should emphasize, as standard provision under the New York Convention that gives contracting states, the power to require reciprocity in terms of the fact that the other state is also a party to the New York Convention. So in England, I think the first thing you need to check when bringing an application to enforce an award is the question of whether the seat of the place where the award was granted is a contracting party, because England has made that reservation of reciprocity, that it would only recognize an award which has been made in the contracting state. So I guess once you clearly made that threshold, then of course it all appears so straightforward, because under Section 102, it merely says that you bring an application, a written application, which is through the arbitration form, and most of the time it's done ex parte, although of course the court may require service on the other party. And I think it's also the same way you need to exhibit some of the key evidence in terms of, for example, the award. You need to, if for example it's not in English, you need to translate, and then of course you need to give evidence that this award has not been satisfied, or if part has been satisfied, you indicate the outstanding sum that needs to be paid. So it's essentially the same similar process, but of course, like I mentioned, you need to be clear in terms of the fact that the party is a contracting state, because England has made that reservation. So that's just the key points to highlight for England and Wales.
Thank you very much, Opey. And what I gather from everyone's explanations is that save for certain complications in respect of the pure recovery of assets. Procedures to obtain exequatur before the respective judges is not that complicated. But as Marie and Mourad said, most of the debates are going to occur if there is a rejection of the exequatur order, of the exequatur application, or if there is an appeal of the order granting exequatur. And that allows us to move to the third part of our discussion, which is the hurdles, the actual hurdles to the enforcement. And Opey, you mentioned the importance of looking at the New York Convention, and New York Convention, one of the grounds for setting aside of an award or refusing exequatur is not refusing exequatur, but for setting aside refusing enforcement is the annulment of the award at the place of the arbitration. Now, the situation in this respect is not the same in all jurisdictions. And Marie, let's assume, taking my example, my earlier example, I'm coming to you with my award, and there is just one tiny little thing that I didn't mention to you, is that this award was rendered in another jurisdiction than France, and it's been annulled. Can I still enforce it in France, or am I precluded?
Thomas, as you probably well know indeed, in France, it's still possible to get the enforcement of an award which had been annulled at the seat of the arbitration. And it's a well-established principle under French law. We've got very famous case law, starting by in Marton with a decision rendered in 1994, and then the also very famous Putrabali cases rendered in 2007 by our Supreme Court, la Cour de Cassation. But the very interesting thing, although France has a specific case law, and we will discuss further that in other jurisdictions it's not possible to enforce decisions which were annulled at the seat. A recent decision is worth mentioning, and it's a decision called the Natgas case, and we've got a sort of a judicial saga because first there is an exequatur process, then an appellate process, and the decision was lately rendered by our higher jurisdiction, which is the French Cour de Cassation. In this case, the specific is that it's an Egyptian arbitration regarding the increase some pricing element, and at the end an award is rendered in 2009 by an arbitration panel in Egyptia, and it's an award worth approximately 30 million euro, at least the equivalent in Egyptian pounds, so it's not a small amount. And the year after, the Cairo Court of Appeal annulled this arbitral award on the ground of public policy, and the reason why was that the ministry has not provided necessary authorization to engage a public body into an arbitration proceedings. And then roughly at the same time, the winning party, at least at the arbitration stage, requested enforcement before the Paris High Court, and obtained an enforcement order. And then the enforcement order was challenged. At the appellate level, the Court of Appeal stated that the enforcement order was okay, and at the level of the High Court, the Cour de Cassation, in a decision rendered on January, it was the 13th, the Cour de Cassation rejected the further challenge of the appellate decision before our Supreme Court. And the interesting finding is that also the award was rendered, and that one party claimed that it was a domestic award. French Court de Cassation clearly said that there is no difference between international awards, and the decision was made clear by the Poutrabali jurisprudence and even in Marton. But now looking into domestic award, the same solution applies. Why? Because the way our civil code of procedure is drafted, and it's always good to refer to the heading of the article within your code of civil proceeding, and I'm referring to article 1514. It's about recognition and enforcement of arbitral award. And this chapter 3 refer to international arbitration, but also to awards made abroad. And the ruling of the Cour de Cassation is pretty clear. Award made abroad can be of a domestic nature. So there is no distinction to make between international awards and domestic award. The solution is plain and simple. You can seek enforcement in France in both cases.
Thank you, Mary. It was indeed a welcome specification. It's a case law that has been established for more than 20 years. For more than 20 years now, and even almost 30. And it's true that we're happy to know that an award can be domestic from the perspective of the jurisdiction in which it was rendered, but obviously foreign in France, and therefore allowed to be enforced. So that's quite interesting. Now the situation is not as clear-cut as in France, in other jurisdictions, and I think, Opey, that in England, it's still possible to enforce an award that has been an order de seat, but under more stringent conditions. Is that correct?
Right, that's very correct. I think the general position in England is that, the courts would generally not enforce an award that has been set aside at the seat, and which is why it's very important, especially in practical terms, to consider the seat when making a choice as to where you want your arbitration to be held. So you want to go to a seat that is friendly. And coming to the real issue is the fact that because in England, the understanding is that an arbitration award is clearly connected to a seat. And because the seat has supervisory powers and jurisdictions over that process, where there has been proceedings and ultimately that award has been set aside, then the court more like will recognize that foreign decision. And that is because of the fact that we do not see arbitral procedures as floating in the transnational firmament, unconnected with any municipal system of law. We do see an award that's connected to the seat. So where that seat, the court of that seat has made a decision to annul the award, the English court will generally recognize it. However, there's a bit of nuance to this, and that's why it becomes interesting in terms of, in some cases, English court will refuse to recognize that foreign decision, setting aside an award under very stringent conditions. And that is where, if the decision offends basic principles of honesty, natural justice, and domestic concept of public policy. So you can see clearly that it's a practically high threshold to cross. But that is not to say that that has not happened. I mean, in fact, in the famous Yukos Capital case, we have a situation where an award has been set aside in Russia. And then the award creditor got paid the full sum of the award. But then, of course, he now came over to England to seek and claim the interest on those awards, even though it's been set aside before the Russian courts. And the question before the court was whether it should enforce or it should order payment of interest. And so the court then had to look into the question of the basis or the reasons for the annulment. And one of the things that came out before the court was the lack of natural justice in the proceedings in Russia that annulled the award. So which is one thing that offends the requirement of natural justice in England. So it's always the case that the court will want to look at what was the basis of the annulment. So unless there's clear and cogent and convincing evidence of violation of principles of honesty, principles of natural justice, and concepts of public policy in England, English courts will generally enforce. So it's always the fact that it's potentially something very difficult to cross that threshold. So that's what we have in England. So it's unlike in France, where they clearly say that it's a transnational order of things. No, in England we tend to think in terms of there's a connection between the seats, and therefore we will look at and recognize that foreign decision unless you can show that the proceedings leading to the annulment, violate the principles of honesty and domestic concept of public policy.
Right, thank you very much. So unlike in France, where the enforcement of an award annulled the seat is going to be the principle, that would be the exception under English law. And Mourad, if I'm not mistaken, when we prepared this webinar together, you mentioned that there are currently no decisions that have been rendered on this aspect in Algeria, correct? So that remains an open question. You're muted.
Sorry, we couldn't identify. Yeah, we couldn't identify any particular decision from the Algerian Supreme Court in relation to this topic. But in practice, I would say the Algerian Supreme Court in relation to those questions is quite influenced, I may say, from the French Cour de Cassation, and it may be possible that Algerian Supreme Court may follow what the French Cour de Cassation has taken.
Well, let's look interesting open issue. Let's look let's see what the future holds for us in this respect before the Algerian judge, and that was one of the first potential hurdles, but there are other areas of uncertainty or difficulty, and in particular, what if enforcement is sought against a sovereign state? We know that states benefit from particular specific legal protection Ope, would you like to take the lead on this one and explain to us briefly, if possible? It's a very wide topic. How things what are the major hurdles when the respondent is a state?
Right. I mean, like you mentioned, it's a quite extensive field to cover, but of course, in England, the key statutory provision here is the State Immunity Act of 1978. And the general position on that section 13 is that you don't have enforcement against the property of the state, right? And of course, which is the point that in any case, before even bringing any enforcement application, it means that you've gotten a judgment against the state or you've gotten an award against the state. So you've already crossed the first hurdle in terms of, immunity against legal proceedings. And so the real issue here is that before you bring enforcement against the state, especially talking in the context of an arbitral award, the only exception is that that property must that which is used for commercial purposes. So the provision clearly says under section 13.2 that you can only enforce against the property in use or intended for use for commercial purposes. So it's very important to clearly identify, what purpose this asset is used for by the state. If it's used for commercial purpose, then potentially you can enforce against that. But then there's a further interesting bit of it, which is that this property, must be used exclusively for commercial purposes. So, which makes it really more difficult in terms of identifying what assets you can actually enforce against. And I guess one of the things, or one of the practical ways to overcome this hurdle, although potentially difficult, is to include in your contractual documents, exclusive provisions by the state waiving their sovereign immunity, which are, of course, like you will see in practice, is very difficult to get. And if that does not happen, then you then have to show clearly that this property of the state is used exclusively for commercial purposes. And I think I should also mention that there's a further more difficult one to cross, which is in terms of assets of state central banks or other monetary authority. For them, they actually enjoy a more special position in England, which is that there's absolute immunity for them, regardless of whether assets are held for commercial purposes or not. So when the central bank of a state is concerned, the court will not investigate into the status or the basis upon which that property is held. So there's more or less an absolute immunity for this bank, which is why it becomes more practical to consider these issues well ahead of time, especially at the point of entering into any commercial relationships with state central banks or any monetary agency. So because there's more or less what we call an absolute immunity for them in England and Wales.
Thank you very much, Ope. And how is the situation in Algeria? Is that as stringent?
No, it's not exactly the same. We don't have this distinction on commercial properties, but I will say that first, there is a general principle under Algerian law is that any person may compromise on its rights, except when dealing with public order, the state, or the capacity of individuals. This rule is provided by Article 1006 of the Algerian Civil and Administrative Procedures Code. The principle is that the state cannot recourse to arbitration except when the state is involved in international economic relations or is part to a public procurement contract. Therefore, the Algerian state subdivisions, such as ministries, wilaya, which is the equivalent of the French prefecture, or state-owned establishments, etc., may not choose arbitration as the dispute settlement forum, except when they are involved in the framework of an international economic relation, for example, a dispute involving BITs, or in the framework of a public procurement contract. Then, once you obtain an award involving a dispute related to a public procurement contract or an international economic relations involving any of the ministries, wilaya, etc., the procedure of exequatur in Algeria is exactly the same as the one we described previously, except that if it is involving the regulatory bodies of the states, such as the ministries, as I said, then the exequatur procedure must be introduced before the administrative court. And once you obtain the exequatur, the same rules are applied also for the enforcement, except that you will not be able to obtain the seizure of an immovable asset of the specific ministry. So you will not be able to seize a particular building or land which is owned by the particular ministry. However, you will be able to either seize the General Treasury bank account and request immediate payment within the 15 days deadline, as we have seen previously, or you will be able also to seize a bank account opened before a local bank by any of the state subdivisions. So I think it's quite different from England, and most of the time is in practice it's the state when it is involved in commercial relationships, in particular in public procurement contracts, they will not raise an argument related to the sovereign immunity of the Algerian state. In particular, for example, you have seen several awards against Sonatrach or against the Algerian government in relation to telecom cases or hydrocarbon cases where most of the time the Algerian government has paid the fines granted under the particular award.
Right. Thank you very much, Mourad. That's very interesting. And in fact, I'm looking at Marie because we see here that there are different standards and different criteria, different categories actually of for the same, more or less the same attachable assets. I think the situation has become slightly more complicated than it was in France since 2016. Would you like to briefly explain why, Marie?
Yes. Okay. In principle, if you manage to get the exequatur, your award is enforceable, and you can go and request a bailiff to conduct enforcement measures. That's why France was really seen, and especially in the context of the Yukos saga, as a few years ago, as a favorable area in order to enforce international awards, and the fact that, of course, sovereign immunity and restriction for enforcement against state entities did exist, was not seen as a very, very big hurdle. But the condition dramatically changed after a law that was enacted in 2016, and this law, in a sense, has been criticized because it was rendered in the context of the UCOS, enforcement attempts in France. And right now, the regime is completely different because, as previously mentioned, generally speaking, if you enforce against a private party, you just need your exequatur. Here, you need to seek from the judge, from the French judge, on an ex parte basis, a special authorization to enforce against state entities. And this special authorization is solely granted if you can establish that the targeted assets have been that the states consent to the measure, which is in fact very rare. But the other way is to establish that the assets are of a commercial use. And at the same time, French law have set so many exceptions, widening the sovereign protection to diplomatic assets, to military assets, to cultural assets, to any scientific, cultural, historical goods, also to any tax receivable or social tax receivable, that in practice it's now very complicated to seek enforcement against a sovereign state in France, and it's a big change, and it's really a very different regime right now.
Absolutely, France is not an enforcement asylum against states. Before we move on to the questions which we have in the Q&A, we have one subtopic, the last hurdle that we wanted to envisage together today, which is what happens if a party applies for a stay of enforcement. Marie, you mentioned the provisional enforcement that you can ask in the awards that it be ordered. But what happens if a party applies to the judge and asks for the stay of the enforcement? Is it possible? How is it stringent? How does it work?
In practice, there is, a way to go before the judge. Would it be through a summary proceeding, or going before the judge in charge of the case if there is at the same time an annulment proceeding against the award, or a challenge of the enforcement order? However, the condition set is really stringent. You may establish that enforcement would severely prejudice the right of one of the parties. And if you look at the case law, it's nearly getting bankrupt, or so you need to have a very good case. And being able to show financial records, analysis from the auditors, explaining that the financial situation is really very, very severe and difficult. The other way, which is much more used in practice, and I guess my colleagues are going to speak about that, is to discuss setting the condition for enforcement. which in practice either escrow, putting the fund into an escrow account, or negotiating a first demand guarantee, or a bank guarantee in order, in case of annulment, in order to recover the fund. So there is most of the time a discussion about getting some kind of financial tools in order to get the setting of the condition of the enforcement.
Thank you very much, Marie. And you rightly mentioned that Mourad and Opey would probably talk about that. What's the position in Algeria, Mourad, in respect of staying the enforcement? Do you have, for instance, to post a security for cost? How does it work?
In Algeria, it's very difficult to obtain a stay of enforcement, because once you have introduced the appeal on the exequatur that has been rendered by the judge, the appeal is not suspensive of the execution. As Marie said, it may be possible to introduce under summary judgment procedure a stay of enforcement on the basis that there are new facts or a high risk of loss if enforcement is granted. For example, what I explained previously on the risk of transfer outside of Algeria of the collected funds. In addition, we have seen once a case where a stay of enforcement has been granted exceptionally because a bank guarantee has been put in place in favor of the winning party in the event the appeal is at the end not granted. So the principle, generally speaking, is that the appeal is not suspensive of the execution, and in a very rare cases, you may obtain a stay of enforcement in the event there is a high risk of loss of the funds that will be collected and transferred outside Algeria.
Thanks a lot. And before we move to the questions, Opey, how does it work, the stay of enforcement in England?
I think the situation is also substantially similar to what we have in France and Algeria, like Maria and Mourad has mentioned. Of course, the key conditions is to show, for example, that the annulment application before the seat is, made bona fide, and it's simply not a delay tactic. So you need to show clearly that, and some of the things you can evidence is, of course, by showing that there's a real prospect of success in the proceedings. So it's also very important. So, for example, the question in terms of whether it's a delay tactic is whether annulment proceedings were brought after the enforcement has been sought before the English court. So that creates a real test for you to show that it wasn't a delay tactic. And of course, there's also the point the court will look at whether a delay or an adjournment, will cause any prejudice to the award creditor. So the conditions are more or less what we have in France and Algeria. But of course, when the court decides to grant a stay, it may then require you to, put down security for that stay of adjournment, because, of course, like when an award has been granted, it's normal for you to clearly get the fruit of your labor, like if I'll call it that way. And where you are seeking to stay enforcement, the court will want to be sure that it's the proper thing to grant. And when it does decide that it's the proper thing to grant, it may then require security. And this is usually the case, for example, where there's a risk that asset might be dissipated, like we've mentioned before. And in fact, in one recent case as 2014, the court even granted a full security for the value of the award. And the reason being that there was clear evidence that the award debtor would clearly restructure his assets out of English jurisdiction by the time a challenge, pending in the New York court was determined. So because of that, the court said, you have to put down the full security for the value of the award. So you can see how many of these things work. But of course, I should mention one point in terms of when the court will grant will require security. It is usually where it is the award debtor who is seeking an adjournment and not the other way around. So it must be that, it's the debtor who is seeking an adjournment. For example, if it's the award creditor who is seeking an adjournment, there's no jurisdiction in the English court to order security for the award. So it's really something similar to what we have, but of course, to just highlight the fact that we have that requirement for security, and sometimes it can be full, like we had in private school restructure holdings, like I mentioned.
Interesting. Thank you very much. So everybody has been pretty disciplined on time, so that we have 15 minutes for questions, and we already have questions in the chat. And the first question, Mourad, is for you, I believe, because it relates to the first topic, i.e. This narrow interpretation of the Algerian judge of the notion of procédure au fond, procedure on the merits. And the question that comes from Wan Trantang of Peter and Kim is there a way to seize the Algerian courts to, with a declaratory relief, to declare the existence of the ongoing arbitration, which arises out of the consent dispute, to then present it as a validation, as the basis for validation for the provisional measure? Is that possible, or in effect, will you always, in practice, will you always have two parallel proceedings, basically?
Yeah, I mean, as I said previously, the rule, generally speaking, most of the judges here will not grant a validation if in the same time there is not a claim on the merit introduced within 15 days before the same court. Now, we have seen in the past one or two cases where we requested to the judge to validate the temporary measure pending a decision before the arbitral tribunal is rendered. So we explained to the judge there is an arbitration clause, and therefore the parties cannot submit a case on the merit before the court, and the judge should, in this case, declare itself incompetent to review the merit of the case. And that's why we asked the judge to still approve and validate the temporary measure while an ongoing arbitration is pending, or an arbitration will be starting in the coming days. And as I said, we have seen only one or two times a favorable decision, and those are very rare cases.
Thank you very much. So one, to a certain extent, you can be reassured. There can be a solution to avoid this narrow the problems that can arise out of this narrow interpretation that Mourad so eloquently explained. And we have a second question, although as Mourad said, it would be very rare. But we have a second question, which is probably oriented for Opey and Marie. It relates to the enforcement of awards. I know that the seat it's somewhat different. The question I'm reading it out loud. The question as to whether a court will enforce an award annulled by the court of the seat is an interesting one. However, what about the situation where court other than the court of the seat has the jurisdiction to annul an award, whether such annulment will be recognized anywhere else? What are the panelists' view on this? Let's start with Opey. I think, Opey, you wanted to share some insight on this. And then Marie, if you so will.
Right. I mean, I think it's very, very interesting, of course, to see in terms of when the award has been annulled by a court other than the sixth. Because if you look at it, under English law, it's actually very express that an award would always be recognized unless a number of conditions apply, which is similar to what we have under Article 5 of the New York Convention. So one of the things is that it must be clear that the annulment is made by the court of the sixth. So like I mentioned before, the enforcement process is essentially usually a summary procedure. But one of the things that can happen is that the court has the power to make factual inquiries as to the sixth. So in this case, we've seen cases where the court then goes into a factual investigation as to what is the seat of the award. So for example, there have been arguments as to whether using a venue or using venue in an arbitration agreement equates to seat. So the court will make a factual inquiry and see whether the annulment has been made by the seat. Where it is the case that the annulment occurs other than the seat, of course, the English court would clearly disregard that annulment, because it's very important, it's very key that the annulment must be coming from the state which is the seat of the award. If that is not the case, English court will not recognize that annulment. So I think that that's really sensible, because it's always some of the things that we have where parties sort of go to any courts that they think might easily grant annulment. So, but when you come before the English courts and bring such decision, the court wants to see if that is really an annulment coming from the state. If it is not, English court will not recognize that.
Right, and Marie, do you have comments on this issue with your perspective?
Pierre, very quickly. I think the idea is really interesting. I believe that in terms of French analysis, you are going to check which court did render the said decision. And I think if it's a European court, meaning one of the member state courts of the European Union, giving the fact that there is no review at all of such decision, as there is a very, let's say, completely simplified enforcement process, and in some instances even no review at all. You will have a debate not before the juge de l'exéquatur, but before the juge de l'exécution. I could translate it, juge, enforcement judge, and it's not the same judge, and is going to check if there is enforcement measure, whether there is a debt or not. So interesting questions, and you may also face a situation where contradicting decisions over the merits has been rendered before different domestic courts. So And I think that the fact that really in terms of enforcement right now, it's a worldwide game, and the good way to play it in a strategic manner is to know precisely the rule from the jurisdiction where enforcement may be sought, and think of this question at the outset, and to put everything in order to maximize your chance to get your results.
Absolutely. The question was put by Miss or Mr. Anonymous Attendee. So Miss or Mr. Anonymous Attendee, you've put your finger on a little cog in the mechanism that can indeed create a lot of issues and discussions and debates, as Marie said. So that was the last question that we had. Thank you very much to our three brilliant panelists for this walk through the process of enforcement in your respective jurisdictions. Thank you very much to Bennani Associés and to Delos for having organized this seminar, and thank you very much to the audience.